Welcome back to FARMcast, a production of the University of Nebraska-Lincoln Center for Agricultural Profitability. In this 4-part mini-series, we're exploring the 4 essential components of a strong farm succession plan. We're joined by succession planning expert and extension professional Jessica Groskopf, who shares practical strategies to help farm and ranch families navigate the future with confidence. In today's episode, we're focusing on estate planning, which includes 4 key legal documents: a will, a trust, a medical power of attorney, and a business power of attorney. We'll discuss the role each of these documents play in a successful business transition, common misconceptions surrounding estate planning, and important considerations as you begin developing a plan that reflects your family's goals.
The last type of planning that we talk about when we talk about complete succession planning is estate planning. Well, Jessica, isn't that the same thing? No, it is not. Estate planning is a huge component of this, but I will promise you, an estate plan does not make a succession plan. Having an estate plan in place basically tells the government what you want done at your death. It basically allows assets to be passed from one person to another person through a legal process. It does not teach someone how to manage a farm or a ranch business. And this is where farm and ranch families get stuck, is they went to an attorney, the attorney created the estate plan, but they did not work with them to do what Anastasia discussed and really put together that business and that succession plan to make sure that the business is profitable, that we have someone who can manage it, and that we have a retirement plan for that older generation. So you might have an estate plan in place, and you might be thinking, oh, well, we're good. No, you're not. We have to have all 4 components of the planning process in place in order to make sure that this farm or this ranch or business can survive the death of the oldest generation. And it includes 4 basic documents. Every adult within a farm or a ranch business in the state of Nebraska, an adult is 19 years and up, okay? So 4 basic documents. You need a will. A will, basically what a will does is says, I want these things to go to these people. It also assigns a guardian for your minor children, and it assigns what we call in Nebraska a personal representative. And that person has the joy and pleasure of making sure that these assets go to these people. Assets that pass through the will are subject to a process called probate. Well, what is probate? Probate is that physical process of retitling those assets to these people. Okay. Probate gets a bad rap for a couple of reasons. Number 1, probate is public. Number 2, probate can be costly because some attorneys will charge a percentage of the estate that is probated. So if you're going through the probate process, I actually encourage you to find an attorney who charges by the hour, not as a percentage of the assets. And number 3, probate can take quite a bit of time. So if we're running a farm or a ranch business and we have said that these assets will go to these people and it takes 2 years for that to happen, that is difficult for a farm or a ranch business to keep operating during that time. It just creates a lot more complexity. Now, in Nebraska, whether you like it or not, whether your assets are probated or not, your estate will still be public because in Nebraska we have Nebraska inheritance tax. So avoiding probate because of the public manner of it honestly isn't really an argument, because if somebody wants to be nosy and they want to find out what you passed at your death, they will be able to look that up because of the inheritance tax, regardless of whether your assets were probated through a will. If you die without a will, you will be subject to Nebraska intestate laws, which basically is the default rules of the state of Nebraska of how your assets will be passed. Most people say, well, it'll just go to my spouse. Not in the state of Nebraska. No one likes the government's plan for anything. So if you write a will, that will supersede the state laws. So again, we recommend that you have a will just to supersede the state laws. The second, third, and fourth document that are on this list have to deal basically with your end of life or your incapacity. So I often think about these in the event of disability or incapacity. The most obvious one being something like Alzheimer's. Okay. So the first is a power of attorney, and depending on how you set this up, it could be a durable power of attorney or a general power of attorney. And basically, this person is an agent who will take care of the business aspects that you assign to them through the power of attorney document. Again, I like to think about this in the event of disability or incapacity, but you can define when it is in force and what actions this person can take through the power of attorney document. 3 and 4 may be separate documents, but they may be combined. I've seen it both ways. It just depends on what your attorney who's preparing the documents prefers. So the next item is a power of attorney for healthcare. This is someone who can make healthcare decisions on your behalf. And then the final document is a living will or a healthcare directive that basically states what kind of care you want. Okay. So again, 3 and 4 can be combined. The thing that's important here is that the first document, a will, is only enforced after your death. Items 2, 3, and 4 are only enforced while you are alive, and they expire at death. So let's think about who we are putting in each of these positions. The first thing is that I do not like to see co-personal representatives or co-powers of attorney. The problem with naming two people to that position is that basically you are forcing them to make decisions together, and that often causes tension within families. So what I like to say is you want to pick the best person for the role. So think about who the right person is for that role and name one person to each role. The other thing I will say is it's often more smooth if we can make the power of attorney and the personal representative the same person. If I am the power of attorney and I'm dealing with your business decisions prior to your death, then I pretty much have the information or have a lot of information that I will need to be your personal representative after death. Okay. So again, I also like to think about the ease of that transition between dealing with your business affairs prior to death and then after death. I typically like those to be the same. They can be different, it's not required, but having seen families go through this process, I think it's more smooth when that happens. Okay. The other piece about this is you might be sitting here thinking, well, Jessica, I already have these things in place, but I'm just not really sure. Any of these documents can be updated or replaced at any time, given that you are competent. So while you are alive, you can update these documents. I do see a question in the chat that says, can you bypass the probate process? Great question. Yes, you can. So let's check out our next slide. The most common way to bypass the probate process is by using a trust. Okay. Not everyone needs a trust. Again, this is the you may want or need a trust. It is not required. A trust does not replace your will, it complements your will. Well, what is a trust? A trust is a bucket. Basically, it's like a container that holds your assets and helps with that process of transferring them. The cool part about a trust or this trust bucket is that you get to write the rules of how the assets are used, who benefits from those assets, and how the assets are removed from the bucket. So gives you a little bit more control over those assets and can be a really useful tool. Now, I want to be very clear here. Not everyone needs a trust, but they are a popular tool for farm and ranch families. It does avoid the probate process. The only thing that I see, or one of the things that I see with trusts is that if we create a trust, we have to put things in the bucket. Okay. So there is a physical process of what they call funding the trust that must be done. So we must place assets within the trust. So my assets, if it was my trust, would no longer be titled to Jessica Groskopf. They would be titled to the Jessica Groskopf Living Trust. The important part about this is in the state of Nebraska, there's a limit to how many assets you can own prior to the probate process, which I believe is currently $100,000. So if I have more than $100,000 sitting outside my trust, we're going to trigger a probate. So that's why we have to make sure that everything goes into the trust bucket. Again, this is not a replacement for a will, it is a complement to the will. And basically, what will happen is your will will say everything goes into the trust. We call this a pour over or residuary clause in the trust. Your will is very simple. Moving forward are funeral instructions. These typically are not legally binding documents. Funeral instructions are just usually the first thing that your family is going to look for. And if you have strong feelings about what you want as far as a funeral is concerned, you can place those in funeral instructions. And the final piece is the bequests of personal property. I will tell you that more fights happen over things like heirlooms. I have grandma's yellow pie plate here, the spinning wheel that came from Germany, or the quilts, or whatever it happens to be. That causes more fights in families than anything else. Typically, an attorney is not going to allow you to put those personal property items in the will. They're going to ask you to create a list called a bequests of personal property list. Please do this and do it the right way. In Nebraska, it can be typed or it can be handwritten. However, it must be signed and dated. So basically, it's a description of the item and who it goes to. It does not require an attorney signature or anything. You just have to keep this list, and they usually will give you like a form to write this out on. Do not play the put the sticky note on the back of something game. Do not do that. Why? It's not legally binding. And magically, there are two sticky notes. There's one on the back and one on the bottom. Magically, there's two different handwritings. Magically, the sticky note just fell off. Again, if we're talking about reducing the tension within our family, let's do things the legally correct way. And in the state of Nebraska, that's a bequest of personal property list. I want to round out the question about bypassing probate. The other assets that bypass probate are payable on death, transfer on death, named beneficiaries, specially titled assets such as joint tenants with rights of survivorship or life estate deeds. Those also pass automatically at death and they avoid probate. The problem is when you have a will and you have those payable on death, title or transfer on death, or beneficiaries or special titles, you need to make sure that it matches your wishes. The kicker of an example there is someone who has a life insurance policy that has a named beneficiary that's their ex-wife. Guess what? The ex-wife gets it if she's still the named beneficiary, regardless of what the will says. Because those assets do not pass through the probate process, they transfer automatically at death. So I really encourage farm and ranch families to go through as a part of this process and review all of their accounts, all of their titling, all of their insurance policies to make sure, again, payable on death, transfer on death, named beneficiaries, and titling is all correct. When you go through that process, you may also discover, like Anastasia said, that things you thought were a certain way weren't a certain way. So again, the LLC owns something versus somebody personally owning something is very common within farm and ranch families.
Thank you for listening to another episode of FARMcast, a production of the University of Nebraska-Lincoln Center for Agricultural Profitability. For more information on succession planning or the Nebraska Land Link program, please visit CAP's website at cap.unl.edu.